What are the top 8 ways for getting approved for disability benefits in Georgia? Hi, I'm Jonathan Ginsberg, and I'm a Georgia Social Security disability attorney. And I've been trying disability cases throughout Georgia and hearing offices throughout the state for over 25 years. And over that time, I've learned a lot about what judges like, how they react to certain things, and what you need to do to win. I want to share that information with you today. So I want to go through the top 8 ways I think that you can improve your chances at winning. These are in no particular order, but I do think you ought to keep them in mind when you apply for disability benefits. Okay, let's get started. The first thing I'd like to tell you is when you apply for disability benefits, you really want to avoid having gaps in your medical treatment. And what I mean by that is if you've gone to the doctor and then you stop going to the doctor for 12 or 18 months, then you go back to the doctor, the judge is going to want to know, why did you stop for a year, year and a half? Were you feeling better? Were you out of state? Were you in prison? Whatever the case may be, you have to be able to give an explanation. But gaps in treatment are a problem for a judge because it really stands out. If you're saying, I can't work because of a medical problem, and there's an 18-month gap in treatment, that is going to raise a red flag for the judge. This is especially the case if the gap is fairly recent. So if you say, I've had severe low back problems for the past 10 years, and you treated for 6 or 7, but the last 2 years you've really not gone to the doctor, the judge is going to want to know why. And the conclusion will be, unless you give some of the reason, that you were feeling better. So a gap in medical treatment is a problem. Judges expect to see you going to the doctor for all of your medical issues ongoing, and I tell people at least 3 or 4 times a year. I realize a lot of folks don't have money, especially if they're not working, but again, for Social Security purposes, the judge will say, I don't really have anything to go on, and you can't really rely on the consultative evaluation, so if you have a gap in treatment or a lapse in treatment, that is a real problem for Social Security disability. The second thing, you always want to have a firm diagnosis, and ideally one that is backed up by some form of objective treatment. So for example, if you're saying, I can't work because of severe back problems, it really helps to have an MRI report, a CT scan, some sort of objective test report that shows what's going on with your back and why you're having that problem. To go into a disability hearing and say, you know, I've got severe pain in my knees or my back or my ankle or my shoulder, but there's no report, and really an x-ray is not going to be enough in most cases. If you don't have an MRI or a CT, the judge is going to say, well, you know, that's just subjective pain, but there's nothing I can really hang my hat on to understand why you're having that type of pain. So objective evidence is really important, and a firm diagnosis. You know, there are a number of diagnoses out there for people with pain that they don't understand what's going on. They call it idiopathic pain, where you may have severe pain in your elbow or your wrist, but there's no necessarily a reason for it. Sometimes you can have something called CRPS, or used to be called RSD, which is kind of a pain syndrome, or even fibromyalgia. These are difficult for judges because basically they're relying on your telling them what's going on without any medical support or any confirmation from your doctor. Very hard for a judge to issue a favorable decision on that. Not impossible, but very difficult. So whenever possible, try to have an objective medical problem with a firm diagnosis explaining what's going on and a protocol of treatment, whether it's medications, physical therapy, surgery, but things that are out of that norm, what the judges expect to see, they're more likely to want to deny. Number 3, whatever treatment your doctor gives you, whether it's medications, whether it's physical therapy, whether it's exercise, losing weight, stopping smoking, you want to be compliant. You want to show the judge you've done everything your doctor has asked you to do. And if you show full compliance, that makes the judge feel like, okay, you're doing everything you possibly can to get better, as opposed to somebody who sort of picks and chooses. The doctor says lose weight, but you don't lose weight. Again, believe me, I know it's hard to lose weight, but anything you can do to follow up what the doctor says, the judges really, really appreciate full compliance with what the doctors have to say. Number 4, when you testify, and also if you can get it from your doctor, some sort of a way to translate your medical issues into specific work limitations. You know, one of the things I think that's really, really helpful in a disability case is called a functional capacity evaluation. This is a form generally that I create, give it to my client's doctor, and ask the doctor to comment about various work-like activities. Because remember, Social Security disability is about your capacity to perform work. In order to be proven disabled, you've got to show you do not have the capacity to be reliable 8 hours a day, 5 days a week, and that this disability, this problem is going to continue on for at least 12 consecutive months. So you really want to make sure you have proof that in fact you do not have the capacity for work and specific things that would impair you and limit you from working. I think you want to practice. This is, I would say, number 5 on my list. You want to practice to make sure that you can explain to the judge specifically what the problems are with your working. And when I mean practice, I mean talk to your lawyer, describe and understand how much you can lift, how long you can stand, how long you can sit. You want to be specific. You want to avoid not very long or not very much. That doesn't tell the judge anything. You want to be as specific as you can describing your limitations. So the more practice you take with your lawyer before your hearing, the better. I know typically I spend an hour to an hour and a half practicing with my client, even though the hearing itself might only last 45 minutes. We're going to go through and we're going to practice answering questions. And a lot of times we start out with, I can't sit very long, I can't do very much, I just piddle around the house. That isn't any good. You've got to be a lot more specific than that. And of course, you're going to be nervous at your hearing. So the best way to get past that is to practice and to know going in. So if the judge says, how long can you sit? The time to think about that is not at your hearing. The time to think about that is 3 or 4 weeks before, so that you kind of commit that to memory, or you've got notes in front of you so you know how long you can sit, how much you can lift, how much you can carry. Can you climb ladders, ropes, and scaffolds? Can you kneel, stoop, crouch, crawl? All these type of things. Do you have problems with attention and concentration? If so, after what period of time? You need to know that stuff before you go into your hearing, because if you wait until the actual hearing, start thinking about it, you're going to waste a lot of time and you're going to come across as being unsure and not entirely truthful with the judge. Number 6, and this may seem a little self-serving, but I'm going to tell you anyway. Get an attorney. Don't go to a hearing without an attorney. Obviously, if you're in Georgia and you're not represented, I hope you'll consider calling me. But if not, call an attorney. You get in front of a judge at a hearing, you got 45 minutes to present your case. And the judge is going to expect that you're going to know what's going on, how to react to his questions or her questions. Do you waive formal reading of the opening statement? Are you prepared to stipulate the qualifications of the vocational witness? Are you asking for an approval on the list? What is your argument regarding functional capacity? If you're arguing for the grid rules, what is a grid rule? A lot of acronyms. You know, what is your DLI, your date less insured? What is your AOD, your alleged onset date? And if you don't know that stuff, you go in there and you sort of expect the judge to be able to walk you through it. I've seen judges that will say, even to me during my hearings, counsel, we have 45 minutes for this hearing. We need to wrap this up or schedule another secondary hearing. So you've got to be prepared to move quickly and to be able to answer the questions for the judge and to know exactly what the judge wants to know. And to do that without having a counsel is really not a very good idea. The other thing, and I've talked about this in other videos, is that once a hearing's been requested and your case is moved from the state agency, you and your attorney are responsible for updating the medical records. I've seen a number of cases where I picked them up right before a hearing. The claimant did not know that, and the last medical record in the files were requested by Social Security a year and a half earlier. You go into a hearing with nothing new for the past year and a half, you're going to lose. So there's just a number of things. It shouldn't be this complicated, but it is. And again, I think at the initial and recon, you can probably muddle through without an attorney, but do yourself a favor and do not go to a hearing without an experienced attorney. That's all I'm going to say about that. Number 7, and these are kind of negatives that you want to avoid, but again, I put it in the top 8 ways to be approved. Don't even have a whiff of drug-seeking behavior or malingering. You don't want the judge to sense at all that you're just in this to get drugs or to sell drugs or anything like that, or that you're exaggerating your symptoms or malingering. Tell the truth to all your doctors. If you go to consultative evaluations, be entirely truthful. Be very, very straightforward, because if the judge senses that you're in this for anything other than legitimate purposes, it's easy just to say, I don't trust this person, I'm going to go ahead and deny this case. And doctors as well will pick up on people that are exaggerating. You want to be entirely truthful. If something's not hurting you, say, it's not hurting me. I don't need to have this considered anymore. But if it's something that's a problem, don't go in there and say, my pain is at a level 10, 24/7. Nobody's going to believe that. It's much more believable to say my pain is at a 7 or 8, 3 or 4 hours a day. It's always at a level 5. Again, these are things your attorney can talk to you about, but just keep in mind that you want to be credible, believable, and completely honest when you're talking to the judge, when you're talking to your doctor, a consultative evaluation, but don't exaggerate and don't do anything to suggest that you're seeking drugs or malingering to get anything other than what's rightfully yours. And the last thing, number 8, which kind of goes sort of hand in hand with number 7 about avoiding malingering and so forth, is don't have an attitude of entitlement. What I mean by that is you go into these hearings with the idea of, Judge, I would much rather be working. I hate the idea of not working. I just can't. As opposed to, I became disabled a year and a half ago. Judge, you got to pay me. I put this money in, I want my money back out. Judges don't buy into that. As far as they're concerned, they're guarding the Social Security Disability Trust Fund. So anything you do, you need to go in with the idea that I'd much rather be working, I don't want to be here, I simply want to, I need some help right now, and if I can go back to work in 5 or 6 months or a year, I'm going to do that. And you want to have the attitude that you're a fighter and you hate the idea of going for disability. So those are my top 8 ways. I hope you find this useful, and I appreciate your time in letting me share this information with you. If you're not represented and you'd like to speak to an attorney, please call me. I'm at 770-393-4985, or you can email me at ginsburg@gmail.com or use the form on this website. I'd be happy to chat with you about winning disability benefits here in Georgia. Thanks a lot.